Hello and welcome back to my channel. This is part 2 of the video because today there has been some filings in the court for It Ends With Us. So get your emotional lip gloss. We're diving right in. No intro, no nothing. This is part 2. And if you haven't seen part 1, we just went over Jennifer Abel's memorandum of law in opposition for Stephanie Jones to be dismissed. And now there's been, let's just look at this. Today filed not one but 2 letters to the court from third parties in support of Blake Lively. Yeah, so the first one is a motion to file an amicus brief, and this was done by Elise Dorsey. And then there was another one filed today, a letter motion for leave of the same thing to file, and that document was filed by the Equal Rights Advocates, and it's in support of Blake Lively using the new law in California for victims of sexual harassment. I'm actually beside myself because first, don't we have to prove that maybe there was sexual harassment? I mean, in any harassment case, you have to prove that it's objectively and subjectively that the harassment has been done. That hasn't been proven yet, and it's been proven that Blake Lively has lied so many times. So it's kind of strange that Judge Lyman put a pause on all letters coming from, other parties and stuff, but yet these have been submitted and I haven't gone over them yet, but we'll just quickly breeze through this. So get your emotional lip gloss because I don't know what we're about to get into. The first amicus curiae is from a woman called Elise Dorsey. This is a motion of Elise Dorsey as amicus curiae for leave to file amicus curiae brief in support of Blake Lively's invocation of the Protection Survivors from Weaponizing Defamation Lawsuits Acts. Elise Dorsey is an attorney and survivor of sexual harassment and abuses of power who now advocates for stronger statutory protections for survivors and for stronger legal remedies for people subject to retaliatory lawsuits. Ms. Dorsey herself was subjected to a retaliatory defamation lawsuit in Virginia after reporting her sexual harassment to the university where it happened and later sharing her experience with the public through the media. To achieve her advocacy goals, Ms. Dorsey has supported stronger anti-SLAPP protections and denounced retaliatory lawsuits against survivors. As relevant here, Ms. Dorsey has a strong interest in advocating for survivors of sexual harassment faced with painful and expensive litigation. She also has a strong interest in aiding courts in upholding codified protection for survivors, like California's Protection Survivors from Weaponizing Defamation Lawsuit Act, so that no survivor must endure what Ms. Dorsey endured over a year and a half of litigation against her harasser. Argument: district courts have broad discretion to permit the filing of an amicus brief. Then she gets into the laws that should allow her to file the amicus brief. Ms. Dorsey respectfully submits that leave is proper here. Ms. Dorsey provides a unique perspective on retaliatory lawsuits as a victim of one herself, and she also speaks to how Virginia's anti-SLAPP statute failed to protect her from such retaliation. As part of her advocacy, Ms. Dorsey can also speak to how state legislatures can protect a survivor's right to come forward and tell her story without facing the chilling effects of retaliatory litigation from their harasser. Ms. Dorsey's proposed brief thus offers valuable additional perspective beyond that submitted by the parties on the importance of protecting survivors from abuses of the legal process for retaliation. Further, Ms. Dorsey's proposed brief describes how this case is not unique, but a common retaliation tactic used by harassers to chill speech and silence their victims. Therefore, Ms. Dorsey's proposed brief provides a unique perspective from a survivor who is not afforded the same protection against retaliatory lawsuits that Ms. Lively seeks to invoke in the lawsuit, thereby supplying unique information which may further assist the court. Therefore, Ms. Dorsey respectfully requests that the court grant leave to file the attached amicus brief. Wow. They are just giving everything they can. I just want to say that both of these documents are 25 pages long, so I'm not really sure I'm going to get through all of them, but we'll kind of see the opening paragraphs and see what this is all about. It's so strange that they both come here, but yeah, this is kind of the table of contents, so we can look at that. Sexual harassment in the workplace and the rise of retaliatory lawsuits. Elise Dorsey's story and how Virginia's anti-slap statute failed to protect her. The unwanted sexual relationship, telling her story. Professor writes slap suit, anti-slap in California, and the importance of its remedies, provision to survivors of sexual assault and harassment. California anti-slap. Mr. Baldoni and the Wayfarers Party's challenge to the Protecting Survivors Act undermines California anti-slap legislation. And the conclusion. Doesn't there actually have to be sexual harassment must have occurred? Guys, let me know what you think here. Very confused, but let's just get into the opening statements. I'm again feeling a little bit infuriated because I too am a survivor of sexual assault, abuse, from a child all the way up until when I was in college. So multiple times in my life. And I don't know. I'm just like, okay. I mean, you could have tons of survivors come out on both sides, right? So anyway, let's get into it. Elise Dorsey is an attorney and advocate for survivors of sexual harassment. Miss Dorsey herself is a survivor of sexual harassment and, like Miss Lively, was subject to a retaliatory defamation lawsuit. As a result of this experience, Miss Dorsey advocates for stronger statutory protections for survivors of sexual harassment, especially for those who wish to speak up about their experience. Blake Lively never spoke up about her experience until the New York Times dropped. It's so, tell me when, where are the complaints? We move on. Miss Dorsey supports Miss Lively's invocation of California's Protection Survivors from Weaponizing Defamation Lawsuits Act, which codifies essential protections for whistleblowers against retaliatory defamation lawsuits. Miss Lively and Miss Dorsey's experiences show that sexual harassment remains deeply entrenched in the American workplace. In just about every industry, sexual harassment derails careers, shatters confidence, and silences voices. And if y'all have been following me for a long time, you already know what I just went through, okay? Like, not too long ago, inside a workplace. You know what I'm saying? So, like, I get it. It breaks my heart that I found so many lies in Blake Lively's story. Like, because that infuriates me even more that she's literally using real life trauma and pain, real life stories from victims and survivors to further this crazy thing. And again, if there is any proof, if there is any evidence, if I see anything now that contradicts what I'm feeling and what I've seen and the evidence so far against and the lies that have been proven that she was lying, and if things start to unfold and come out, I am open for my mind to be changed. Okay? But so far, zero. Okay? The #MeToo movement exposed the widespread nature of such misconduct and empowered survivors to share their experiences. But recent backlash has ushered in a troubling rise in retaliatory defamation lawsuits, which intimidate and stun survivors into inaction. These retaliatory lawsuits are a black mark of our legal system, undermining the fundamental rights of whistleblowers and rendering it nearly impossible to report misconduct. Miss Dorsey's story, like Miss Lively's, exemplifies the disturbing trend. After overcoming years of sexual harassment from her law professor, that is not the same. That is not the same. You experienced years of sexual harassment from your law professor. That's not the same as saying that somebody took too many takes on a kissing scene, lingered on a kissing scene, bit her lip during making out, during a makeout scene. Like, I mean, bruh, okay. It's not the same being in a film, cast in a film, doing these agreeing to do these kind of scenes, this kind of role in this. Oh my gosh, it's not the same, okay? After overcoming years of sexual harassment from her law professor and then boss, Miss Dorsey faced a retaliatory defamation lawsuit seeking $108 million in damage after telling her story. Telling one's story of sexual harassment or abuse is never easy. It is often a last resort. That was certainly the case for Miss Dorsey. She saw coming forward as the only way to protect vulnerable women. Ms. Dorsey first reported the now former professor to the university, which conducted an investigation lasting approximately 20 months and found multiple causes for termination. After this protracted and costly process, Ms. Dorsey and her co-defendant were forced to endure yet another 18 months of exhausting, expensive, and intrusive retaliatory litigation. The plaintiff in this litigation, Ms. Dorsey's former law professor, admitted in private text messages to his friends that he filed the litigation to bankrupt his accusers, not with any expectation of winning his defamation claims. He wrote, "Maybe defamation for fun, but not to win." He explicitly stated that he wanted to bankrupt Ms. Dorsey and the other defendants as punishment for speaking out. Numerous states have enacted legislation designed to combat strategic lawsuits against public participation, SLAPs, like the litigation Ms. Dorsey faced. The Protecting Survivors from Weaponizing Defamation Lawsuits Act, California Code 47.1, the Protecting Survivors Act, is one such statute designed to safeguarding from retaliatory lawsuit survivors of sexual harassment who choose to speak out. By providing a legal shield, anti-SLAP laws can empower whistleblowers like Miss Dorsey and Miss Lively to share their experiences without the threat of protracted retaliatory litigation. By imposing financial consequences on those who bring SLAPs, the Protecting Survivors Act challenges the calculus, adding a financial downside for SLAP plaintiffs, thus deterring bad-faithing harassers from reprising the courts and wasting valuable judicial resources. Elisa's experiences show that without these critical remedies, anti-SLAP statutes offered only illusory protection, forcing survivors to choose between silence and financial ruin, while allowing abusers to escape meaningful accountability and perpetrating misconduct in the workplace. Accepting Mr. Baldoni and the Wayfarer Party's attack on the Protecting Survivors Act would destroy a crucial safeguard for all whistleblowers. This court should not endorse this effort to punish survivors who share their stories, nor should it entertain Mr. Baldoni's and the Wayfarer Party's attempt to invalidate the remedial provisions contained in the Protection Survivors Act. Wow. And then it goes into the background. Like, the judge doesn't already know the background. He has all of the complaints. Blake Lively and Justin Baldoni were co-producers and lead actors in the film adaptation of Colleen Hoover's novel Ends With Us. After the film's release, Miss Lively filed a complaint against Mr. Baldoni as well as Wayfarer Studios. No, she didn't. Not after the film's release. Not after the film's release. After she took over the entire edit, pushed Wayfarer out, forced Sony, blackmailed Sony to give her every single thing she wanted, which included new editors, new composers, and the PGA mark, or she wasn't going to use Taylor Swift's music, stole the movie against Sony's commands to play at Book Bonanza, stole it, got them kicked out of every single PR move of the film so that her husband and his agency, Maximum Effort, could do all of the PR, when that PR that Blake Lively and her husband made together, when their own PR failed because it was so tone deaf and completely disgusting, her reputation failed. After her reputation started tanking, she colluded with all of these people in order to get this story out. And what better way? Because even in the apology letter that she wanted Wayfarer and Justin Baldoni and Jamie Heath to sign, it never said anything about sexual harassment. So what better way to sink a man's career and to sink a man's life than to accuse them of sexual harassment? OMG. I'm over this one already. What I'm going to do is read it on my own time and I shall come back with maybe the most important notes if I find anything relevant. But just by looking at it, it goes into the entire history of the Me Too movement. It goes into like everything to do with the Me Too movement. And then it goes into her own story, which has no basis here in this claim. Anyway, all of this to say, for the foregoing reasons, this court should allow Miss Lively to invoke the Protecting Survivors from Weaponizing Defamation Lawsuits Act in this litigation, and it should deny Mr. Baldoni and the Wayfarer Party's effort to undermine the Protecting Survivors Act for other survivors. I'm stunned. And this is only the first one. How rich that just magically 2 of them popped up in the court filings today. I wonder how much Blake and Ryan paid you guys. I'm sure we're going to see it in the future where you guys pop out of, because this is cray cray. The second one filed today is almost the exact same, but this is from Alexis Roniker, partner, and Rebecca Peterson Fisher, partner. And it just says it's regarding Blake Lively versus Wayfarer Studios. Dear Judge Lyman, pursuant to your honor's individual practices in civil cases, Section 1C, Equal Rights Advocates, the California Employment Lawyers Association, and the California Women's Law Center respectfully request leave to submit the accompanying amicus brief in support of defendant Blake Lively's motion to dismiss based on California Assembly Bill 933. A copy of the proposed amicus brief is attached here too. Defendant Lively consents to the filing of the brief. Well, duh, of course she does. She probably reached out to you and paid you to do it. Proposed amici are nonprofit organizations that drafted or champion passage of the California Assembly Bill 933. Equal Rights Advocates. ERA is a national nonprofit legal organization that advocates for gender justice in workplaces and schools across the country. Since its founding in 1974, ERA has been fighting on the front lines of social justice to protect and advance rights and opportunities for women, girls, and people of all gender identities through litigating groundbreaking legal cases on behalf of workers who have experienced civil rights violations, including sexual harassment and other forms of discrimination. ERA has also led vital policy reform to strengthen protections against sexual harassment and other forms of harassment and discrimination in California, as well as in other states and the federal level. In addition, ERA has participated as amicus in scores of cases involving the interpretation and application of legal rules and laws affecting workers' and survivors' rights and access to justice. ERA has a strong interest in ensuring that victims of sexual assault, sexual harassment, and other forms of harassment and discrimination remain able to exercise their rights to speak freely and openly about harassment and abuse without fear of retaliation and intimidation, particularly retaliation and intimidation by perpetrators who seek to use legal systems to silence such victims. ERA drafted and co-sponsored the litigation at issue here, California Assembly Bill 933, and successfully advocated for its passage. They go into the California Employment Lawyers Association, the California Women's Law Association. Now their proposed brief would help this court by explaining the purpose and legislative history of the California symbol. I think the judge knows. I think he's okay. I think he knows the purpose of that legislation. And he doesn't need the history of the bill. Anyone can find the history of the bill. Okay. I'm just shocked. So let's just go into exactly what they want to say here. Just a little quickie. So it tells you what their organization does. It's a champion passage of the California Assembly Bill. What the ERA does, what the California Employment Lawyers does, what the California Women's Law Center does. They already did that. Now let's just read their introduction here. One of Time Magazine's top 100 influential people of 2025. We all know that she got that award from her 2018 donation, right? That's literally why she got it. Was paid for. It was paid for. Hello? And there's a whole rabbit hole I can go down to show you guys how they are all tied in together. The Time 100 is tied into Ari Emanuel, is tied into Ryan Reynolds. It was paid for. And it was from 2018, a donation they made because they were getting backlash for getting married on a plantation. Like, oh. So I'm so sorry. I shouldn't have laughed so hard. I'm going to try to behave. One of Time magazine's top 100 influential people of 2025, Blake Lively is anything but an average person, but her experience of being sued for defamation after speaking out about sexual harassment is all too common. Hundreds of retaliatory defamation suits have been filed against sexual harassment and assault victims for publicly disclosing their abuse in recent years. Indeed, on its legal hotline, Equal Rights Advocates, ERA, has heard from dozens of low and middle income workers, students, and others who were threatened with or faced to defend themselves against such suits in retaliation for speaking about abuse they experienced, or were chilled from speaking out at all for fear that they would become targets of such retaliatory litigation tactics by their abusers. To combat this onslaught of retaliatory defamation suits in 2023, ERA joined Amicus Curiae, California Employment Lawyers Association, to draft and champion the passage of Assembly Bill 933. This legislation clarified that an individual's communication regarding an incident of sexual assault, harassment, or discrimination they experienced is privileged, provided it was made without malice. It was made without malice. Did you hear that? It also created a free shifting provision and authorized recovery of damage. The intent of AB 933 was to protect survivors from defamation lawsuits filed against them, to deter abusers from filing retaliatory defamation suits, and to combat the pervasive silencing of survivors that enable sexual harassment and assault to persist at epidemic rates. No one is arguing that this law is bad. This law is great for actual survivors, for actual victims, without malice. Did you see that? Hello? Wait. Okay, no one's arguing that this isn't a good law. This isn't just a good law for Blake Lively to attach herself behind. The action is the first test of AB 933, and survivors are watching. This action is the first test of AB 933, and survivors are watching. If the law does not protect a powerful and resourced person such as Miss Lively, then survivors without power or resources, the vast majority, will not risk speaking out about sexual assault or harassment at all. The hashtag #MeToo movement taught us the result of that silence: systematic and unchecked abuse at great personal and societal cost. Abusers weaponize defamation lawsuits against survivors to silence them and deflect culpability. I'm honestly... I can't right now. Denying Miss Lively's motion to dismiss would undermine the AB 933 framework and deter future survivors' reports of sexual assault and harassment. Recognizing that defamation suits are effective in silencing victims or coercing them into withdrawing their claims, the California legislation crafted AB 933 to protect survivors' reports in a manner that would avoid abusive discovery. Should this court deny Miss Lively's motion to dismiss and permit the Baldoni plaintiffs' retaliatory lawsuit against her to proceed, it would undermine this carefully crafted framework, not only for Miss Lively, but also for the thousands of current and future victims in California who depend on AB 933's protections and remedies to defend themselves from similar suits. Miss Lively is a public figure, and this lawsuit has captured the attention of the American public. The outcome of this motion will affect the decision-making of other victims of sexual harassment and assault. And what will happen if that is true, and then right? What would happen? They dismiss right now, right? Justin Baldoni and the Wayfarers, they can't sue Lively for the defamation part. And then they go all the way to court and it turns out that Blake Lively was lying. What will that then do to survivors and victims from speaking forward? What will that do to future actresses on set who are being harassed and who are actually being violated? Will they have a voice to come forward and say, no, I don't feel comfortable, no, stop? Or will the higher ups be like, oh, we have another Lively. Oh, she's just like Blake. Oh, tell me you're not being a Blake. Right? Blake Lively, if found to be lying about this entire thing, will have caused more damage to victims and survivors than this defamation counter lawsuit by Justin Baldoni. This is enraging me in ways I cannot even describe because it is so unbelievable. The Baldoni plaintiffs have already signaled their intent to follow the abusive discovery playbook by invading Miss Lively's privacy and disrupting her relationships, as frequently happens with other survivors who speak up. When did they do that? What? That's not their intent. Their intent is to clear their name. This is crazy. Indeed, in a seeming gambit to disrupt her friendship with Taylor Swift, they have subpoenaed the music star even though Miss Swift has no connection to the workplace harassment and retaliation at issue in the dispute. Whether or not these high visibility abusive tactics work against Miss Lively, they almost certainly will deter survivors from coming forward with allegations of sexual assault and harassment in their own lives. Moreover, the public will recognize that Miss Lively's legal defense is forced to proceed will be very expensive. While she is in the privileged position of at least being able to afford a legal defense, low and moderate income survivors are not. Even if the Baldoni plaintiff suits eventually fails and Miss Lively recovers her fees and costs at the end of this litigation, a ruling in the Baldoni plaintiff's favors will chill other victims from speaking out. The specter of having to endure the invasive and traumatic discovery process while also lacking the resources to pay costs or attorney fees during litigation is more than enough to force survivors into onerous settlements terms to avoid further litigation or to dissuade them from speaking out about the abuse they suffered. In short, based on the pleadings here, the Baldoni plaintiff's retaliatory defamation lawsuit is the prototypical suit in the California legislation intended a short circuit by enacting AB 933. It weaponizes the Darvo technique to recast Mr. Baldoni as the victim to undermine Miss Lively's credibility while also attempting to leverage the powerful tool of abusive discovery to further prosecute her. Granting Miss Lively's motion to dismiss based on AB 933 would allow the law to work as intended by providing early protection and relief for survivors who speak out about sexual harassment. Denying Miss Lively's motion to dismiss, on the other hand, will encourage abusers to use defamation suits to silence victims and will chill victims' willingness to report sexual assault and harassment in the future. The exact opposite of the intent of AB 933. For the reasons said above, respectfully urge the court to grant Miss Lively's motion to dismiss. So there you have it. Another couple of people obviously brought in by the Lively parties. I mean, if I know one person who is exhausted, it's the judge. Give this man a minute, okay? He hasn't even ruled on any of the dismissions, any of the dismissals that have been, Blake Lively wants to get dismissed. Stephanie Jones wants to get dismissed. Ryan Reynolds wants to get dismissed. The New York Times wants to get dismissed. Then, without even having a reply from the judge, then now they filed sanctions to have them being sanctioned for the exact same things that they put in their filing to get dismissed. Now they have these people filing letters in support of Blake Lively. I mean, enough is enough. Okay, I can't wait. The judge needs to put his foot down and stop this. This is wow. I know I didn't go through them the way I always go through it and read every single thing, but there's only so much a girl can take. Okay? And I think, again, as a survivor, that was irritating. I think the damage that has been done, if Blake Lively is proven to be lying, is going to be far more worse than this rule. This defamation law. I think her lies have already been proven. I can go over the lawsuits with you. If you want to play devil's advocate, let me know. Drop it down there. We can go over, like we're just reading it for the first time, and compare it to actual facts and evidence. Both alleged, right? But you can see it for what it is. She gave zero evidence, not even dates, like not even actual dates, nothing. No, nothing. Breach of contract, didn't even put a contract in, and then all of her points, the Wayfair people have come back with actual evidence already. Been like, nope. She hijacked this man's movie and forced them out. And when her reputation failed because of her husband, she did this. It's the next plausible step. I don't know what is going to happen here, but that's what just happened. So I don't know. Drop your comments. Let me know what you guys want next. I'll keep looking over the court dockets to see if anything else gets dropped for tomorrow's video, but I'm shocked, and I would like to now go and watch some lawyers and see what people think of this, because I'm not a lawyer, so I don't know. I don't know if this is good, bad. I don't know how this works in the court. I don't know anything, but I can tell you right now, it is, to me, personally, a load of BS. But anyway, drop your comments. Let me know what you think. Talk to you soon. Bye.